Mark your calendars for February 20th, 2026. A seismic collision is about to happen at the Supreme Court, and most gun owners have no idea it's coming. This isn't just another Friday on the judicial calendar. This is the day multiple major gun rights cases converge simultaneously on the nation's highest court, all aimed at answering the question politicians have avoided and lower courts have bungled for decades. Do AR-15 rifles and standard capacity magazines receive Second Amendment protection? The magnitude of this moment cannot be overstated. The Supreme Court has systematically dodged this question for over 15 years. Since the landmark Heller decision in 2008 affirmed that the Second Amendment protects an individual right to keep and bear arms, the court has denied certiorari, refused to hear at least 47 cases involving so-called assault weapon bans and magazine capacity restrictions. 47 times gun owners were told to wait. 47 times the justices kicked the can down the road, while states like California, New York, New Jersey, Maryland, Connecticut, and Massachusetts enacted increasingly restrictive bans on the most popular rifle platform in American history. We are currently seeing a massive convergence. This isn't just one lucky case making it to the top. This is a coordinated, multi-front legal assault on the framework that has allowed these bans to survive. The justices have a long conference list that reads like a Second Amendment advocate's dream scenario. We have challenges to assault weapon bans, standard capacity magazine restrictions, and the core question is simple but world-shifting. Do modern semi-automatic rifles and standard capacity magazines receive the full protection of the Second Amendment? The implications of that answer will determine whether 24 million AR-15 owners are criminals or constitutionally protected citizens. It will decide whether the 44 states that don't ban these items are the outliers or the constitutional standard, and it will settle once and for all whether the Second Amendment is a real right or a heavily regulated privilege subject to the whims of state legislatures. To understand why February 20th is so critical, we have to look at the years of judicial avoidance. Following the Heller decision in 2008 and McDonald in 2010, the Supreme Court essentially went into a decade-long hibernation regarding the Second Amendment. After Heller established that the Second Amendment protects an individual right to keep and bear arms for self-defense, gun rights advocates expected a wave of litigation would sweep away obviously unconstitutional restrictions. Heller specifically stated that the Second Amendment protects arms in common use for lawful purposes, and that the government cannot ban an entire class of arms chosen by American citizens for self-defense. That language seemed tailor-made to protect AR-15 rifles. By 2008, there were approximately 3.5 million AR-15 pattern rifles in civilian hands. Today, that number exceeds 24.4 million. These aren't military weapons. These are semi-automatic rifles that fire one round per trigger pull, identical in function to countless hunting rifles and ranch guns that have never been subject to bans. The AR-15 platform is used for home defense, competitive shooting, hunting, and is the most popular rifle for civilian marksmanship training in American history. Yet despite this overwhelming evidence of common use, lower courts didn't just ignore Heller, they actively defied it. They created a two-step balancing test that allowed them to uphold almost any gun law by simply saying the government's interest in public safety outweighed constitutional rights. It was a rigged game. In 2015, the court denied cert in Friedman v. City of Highland Park, a case challenging Illinois' assault weapon ban. Justice Clarence Thomas wrote a scathing dissent joined by Justice Antonin Scalia, stating that the lower court's decision defied Heller and that the court was abdicating its duty to protect constitutional rights. In 2017, the court denied cert in Colby v. Hogan, refusing to review Maryland's assault weapon ban even though the Fourth Circuit had applied interest balancing, a methodology Heller explicitly rejected. Again, Justice Thomas dissented, noting that the court's refusal to act was allowing lower courts to treat the Second Amendment as a second-class right. During this time, the Supreme Court watched from the sidelines as Maryland, California, Illinois, and New Jersey banned the very firearms and magazines that millions of Americans use for self-defense every single day. This created a circuit-split nightmare. Some appellate courts ruled that AR-15s are protected arms because they're clearly in common use for lawful purposes. Other courts claimed that these same rifles are too militaristic or too dangerous, directly contradicting the Heller standard. The Seventh Circuit upheld assault weapon bans by claiming AR-15s are like military weapons, even though they lack select fire capability and function identically to non-banned semi-automatic rifles. The Ninth Circuit upheld California's bans using public safety interest balancing that Heller explicitly forbade. Then came the Bruen earthquake. New York State Rifle and Pistol Association versus Bruen didn't just strike down New York's carry ban in June 2022. Justice Clarence Thomas fundamentally changed Second Amendment analysis by establishing a text, history, and tradition test. He wrote for the majority that the Second Amendment is not a second-class right subject to interest balancing. Courts must apply a two-step framework. First, does the Second Amendment's plain text cover the regulated conduct? If yes, the government must prove the regulation is consistent with the nation's historical tradition of firearms regulation from the founding era. Under Bruen, if the Second Amendment's plain text covers the conduct like owning a rifle or a magazine, the government must prove that the ban is consistent with the nation's historical tradition of firearm regulation from 1791. There were no assault weapon bans in the 1700s. There were no 10-round limits for the Kentucky long rifle. Bruen was supposed to settle the methodology question. Gun rights attorneys expected that assault weapon bans would immediately fall because there's no historical tradition of banning entire categories of commonly owned firearms. But here is the problem. The lower courts are now in open rebellion. Instead of following Bruen, they are engaging in legal gymnastics. California's Ninth Circuit claimed that 18th century laws against carrying weapons to the terror of the people somehow justify banning AR-15s in 2026. Maryland's Fourth Circuit argued that historical restrictions on gunpowder storage in urban areas create a tradition of banning commonly owned rifles. They are claiming that AR-15s are too militaristic or dangerous and unusual, despite being owned by over 24 million Americans. They are arguing that magazines are accessories, not arms. The reasoning was absurd, but the Supreme Court remained silent. Until now, the legal system is currently in a state of total confusion. On one side, you have judges who understand that common use means exactly what it says. If a gun is widely owned by law-abiding citizens, you can't ban it. On the other side, you have circuits that just recently claimed that AR-15s are more like machine guns than civilian rifles, a claim that is factually, mechanically, and legally absurd. The Supreme Court knows that if they don't step in now, the Second Amendment will exist in two different Americas. In one America, you're a law-abiding citizen with an AR-15. In the other, you're a felon for owning the exact same piece of plastic and metal. The February 20th conference will consider multiple cases, but two stand out as the likely vehicles for Supreme Court review. These aren't random challenges thrown together. These are strategically developed cases with years of litigation, perfect procedural posture, and legal arguments designed to force the Supreme Court's hand. If you want to understand the sheer audacity of the anti-gun lobby, look no further than Veramontes versus Cook County. This case isn't just a legal challenge. It's a rescue mission for the Second Amendment in the state of Illinois. Cook County has maintained one of the most draconian assault weapon bans in the country, and for years they've gotten away with it by claiming that the AR-15 is a weapon of war that has no place on civilian streets. The plaintiff, Luis Veramontes, is a Chicago area resident who wants to purchase an AR-15 rifle for home defense. He's not a criminal. He's not prohibited from owning firearms. He's passed every background check required by law. But Cook County's ordinance, which mirrors many state-level assault weapon bans by prohibiting firearms based on cosmetic features like pistol grips, adjustable stocks, and barrel shrouds, makes it a criminal offense for him to possess the most popular rifle platform in America within county limits. The core of the Veramontes argument is simple, powerful, and based on the Supreme Court's own words in Heller. Arms in common use for lawful purposes cannot be banned. The legal argument is straightforward and devastating. AR-15 rifles are protected arms under the Second Amendment because they are unquestionably in common use for lawful purposes. Data doesn't lie. As of 2026, there are approximately 24.4 million AR-15 pattern rifles in civilian hands in the United States. That's nearly one AR-15 for every 10 adults in America. These rifles are used for home defense, hunting, competitive shooting, and recreational target practice. They are, by any statistical measure, the most common rifle in America. Participation in AR-15 competitions has grown by 34% annually since 2020. The county's defense relies on claiming that AR-15s are unusually dangerous or militaristic, but this argument fails on its face. AR-15s are semi-automatic rifles that fire one round per trigger pull, functionally identical to countless hunting rifles never subject to bans. They fire intermediate cartridges like .2123 Remington or 5.56 NATO, which are less powerful than standard hunting cartridges like .3006 or 308 Winchester. The rifles are not fully automatic. They are not select fire. They are not military weapons. Veramontes spent 3 years in the district court where Judge Rebecca Pallmeyer upheld Cook County's ban using interest balancing analysis that directly contradicts Bruen. The Seventh Circuit Court of Appeals affirmed in a 2-1 decision, with Judge Michael Brennan writing a powerful dissent, arguing that the majority opinion ignored binding Supreme Court precedent. The Seventh Circuit essentially tried to rewrite the English language to avoid the Second Amendment. The case is now at the Supreme Court with a petition for certiorari filed in October 2025, presenting clean procedural posture, a clear circuit split with other appellate courts, and a legal question that cannot be avoided. While Veramontes fights for the rifle, Duncan Bonta is fighting for the bloodline of that rifle, the magazine. This case out of California is a legal marathon that has been running for nearly a decade, and the history of Duncan is a perfect example of why gun owners are frustrated with the judicial system. The plaintiff, James Duncan, along with Virginia Duncan and the California Rifle and Pistol Association, is challenging California Penal Code Section 32310, which makes it a criminal offense to manufacture, import, keep for sale, offer for sale, give, lend, buy, receive, or possess any magazine capable of holding more than 10 rounds of ammunition. Think about the magnitude of this. California didn't just ban the sale of these magazines. They eventually moved to ban the possession of them, even for people who had owned them legally for 40 years. This was a state-sanctioned confiscation order. The legal argument focuses on the fact that magazines holding more than 10 rounds are standard equipment for the vast majority of handguns and rifles in America. Approximately 115 million magazines capable of holding more than 10 rounds are in civilian circulation. That's more than the number of AR-15 rifles, handguns with threaded barrels, and suppressors combined. These are not unusual or rare items. These are standard equipment. Duncan was originally filed in 2017, challenging California's magazine ban under the HELA standard. In March 2019, District Court Judge Roger Benitez issued a brilliant 66-page opinion striking down the ban, finding that magazines holding more than 10 rounds are protected arms in common use. He wrote a masterpiece explaining that magazines are essential components of firearms and that 10-round limits have zero historical basis in American tradition. California immediately appealed to the Ninth Circuit. The Ninth Circuit panel initially upheld Judge Benitez's decision in a 2-1 ruling in August 2020. But then the Ninth Circuit nightmare happened. California requested en banc review, where the full Ninth Circuit reheard the case. In November 2021, the Ninth Circuit en banc panel reversed by a 7-4 vote, upholding California's magazine ban using interest balancing analysis. They actually had the nerve to say that a magazine is an accessory or accoutrement, like a holster or a cleaning kit, and therefore doesn't get Second Amendment protection. Duncan petitioned the Supreme Court for review. In June 2022, just weeks after issuing the Bruen decision, the Supreme Court granted cert, vacated the Ninth Circuit's opinion, and remanded the case back to the Ninth Circuit for reconsideration in light of Bruen. This is called a GVR order, grant, vacate, and remand, and it's the Supreme Court's way of telling lower courts, you got it wrong, try again using the correct standard. Everyone expected the Ninth Circuit to reverse California's ban after applying Bruen's text, history, and tradition test. Instead, the Ninth Circuit doubled down. In October 2023, a new Ninth Circuit panel again upheld California's magazine ban, this time claiming that historical restrictions on gunpowder storage and laws against affray somehow create a tradition of limiting ammunition capacity. The reasoning was absurd. Gunpowder storage laws from the 1700s were about fire safety in wooden cities, not restricting the capacity of individual firearms. Laws against affray prohibited carrying weapons in a manner intended to terrify people, not limiting how many rounds a magazine could hold. There is zero historical evidence that founding-era Americans limited magazine capacity because magazines didn't exist yet. Judge Benitez, back at the district court level, wrote a scathing 71-page opinion in May 2024, again striking down the ban after the Ninth Circuit remand, stating that the Ninth Circuit's historical analysis was a Hollywood production, disconnected from reality. California appealed again. The Ninth Circuit upheld the ban again in September 2025. Duncan is now back at the Supreme Court for the third time. This is a direct challenge to the Supreme Court's authority, and the justices do not like being ignored. This case demonstrates exactly why the Supreme Court must intervene. Lower courts are openly defying Supreme Court precedent. The Ninth Circuit has been told twice to reconsider under the correct standard and has refused both times. If the Supreme Court doesn't take this case now, it signals that lower courts can ignore Supreme Court decisions with impunity. Now, let's talk about the relist phenomenon. If you follow Supreme Court dockets, you've noticed something strange. Both Veramontes and Duncan have been relisted multiple times. In fact, as of early 2026, these cases have been relisted 4 times each. To the average person, a relist sounds like a delay. In the legal world, it's often a signal of a massive move. When the justices relist a case, it means they aren't just tossing it in the denied pile. It means they are discussing it intensely in their private conferences. Why do they relist? First, vehicle checking. They are making sure there are no procedural traps that would let the state win on a technicality. Second, sometimes a justice is already writing a dissent from denial or a summary reversal where they strike down the law without even hearing oral arguments. Third, coordination. They are waiting for other cases to catch up so they can take them all at once. According to Supreme Court litigation data analyzed by SCOTUS blog, cases relisted 3 or more times have a 68% grant rate compared to a 1.2% grant rate for cases discussed only once. Both Veramontes and Duncan have been relisted 4 times as of February 2026. That's a strong indicator that at least 4 justices, the number needed to grant cert, want to take these cases. The fact that these cases are being held and discussed week after week for the February 20th conference suggests that the justices are preparing something significant. The Supreme Court is currently engaging in what legal experts call coordinated review. By scheduling multiple cases from different circuits for the same conference, the court is eliminating its favorite excuse for avoidance, the wrong vehicle problem. They have petitions regarding AR-15 bans, magazine bans, and related laws all hitting their desk at the same time from Illinois, California, Maryland, New Jersey, Connecticut, and Washington. At least 6 separate cases involving assault weapon bans and magazine restrictions have been distributed for the February 20th conference. By taking multiple cases at once, the court avoids the wrong vehicle problem. If California's magazine ban has a weird technical flaw, they can use the Washington state case instead. If the Illinois AR-15 ban has a specific procedural issue, they can look at the Maryland challenge. This consolidation strategy also prevents circuit shopping problems. If the court takes only one case and issues a narrow ruling, lower courts in other circuits might claim the decision doesn't apply to their specific ban because of state law differences. But if the court grants review in multiple cases or issues a consolidated opinion addressing different ban structures, the ruling becomes nationwide and unavoidable. This is strategic brilliance. Instead of chipping away at these bans state by state, the court is setting up a scenario where they can issue a single, sweeping opinion that says, modern semi-automatic firearms and their standard magazines are arms under the Second Amendment, they are in common use, and any ban on them is per se unconstitutional. That is the nightmare scenario for anti-gun governors. They have spent millions of taxpayer dollars defending these bans, and on February 20th, the Supreme Court might finally tell them that the bill has come due. Let's wargame the possible outcomes, because each scenario creates drastically different futures for gun rights in America. If the Supreme Court grants certiorari on February 20th for Veramontes and Duncan, we enter the final phase of this constitutional battle. A grant means the court will officially hear oral arguments. The timeline would move with precision. Briefing would begin in late February 2026. The petitioners would file opening briefs by mid-April, laying out the constitutional argument that AR-15 rifles and standard capacity magazines are arms in common use for lawful purposes, protected by the Second Amendment under Heller, and that the government cannot ban them without proving a historical tradition of similar regulations, which doesn't exist. The respondents, Cook County and the state of California, would file reply briefs by late May, arguing that these items are unusually dangerous, that public safety justifies the bans, and that historical analogs create a tradition of regulation. Amicus briefs would flood in from both sides. Gun rights organizations would file supporting briefs with statistical data on defensive gun use, common use numbers, and historical analysis. Anti-gun groups would file briefs emphasizing mass shooting statistics and public safety arguments. Oral arguments would be scheduled for late May or early June 2026. Based on recent Second Amendment cases, expect Justice Clarence Thomas to press the government on where the historical tradition exists. Expect Justice Brett Kavanaugh to ask about line-drawing problems. If the government can ban AR-15s, can it ban all semi-automatic rifles? A decision would be released by late June 2026, the traditional end of the Supreme Court's term, just in time to become the biggest political earthquake of the decade. If the court rules that AR-15s and standard capacity magazines are protected arms, the opinion will likely find that these items are unquestionably in common use for lawful purposes, meeting Heller's test. The court will find that the government has failed to prove a historical tradition of banning entire categories of commonly owned firearms or limiting ammunition capacity. The court will strike down the challenged laws and remand similar cases back to lower courts for reconsideration. A victory in this scenario wouldn't just strike down the Cook County and California bans, it would create a constitutional blanket over all 50 states. The nationwide impact would be immediate. The 10 states with assault weapon bans, California, New York, New Jersey, Connecticut, Maryland, Massachusetts, Hawaii, Illinois, Delaware, and Washington, would face immediate constitutional challenges affecting approximately 94 million residents. State attorneys general would have three choices: defend the laws knowing they'll lose, repeal the laws voluntarily, or try to narrow the laws to comply with the Supreme Court's ruling. Magazine capacity restrictions in 13 states would fall. It would mean that any state law that attempts to ban AR-15s or limit magazine capacity would be dead on arrival. Millions of Americans would gain legal access to firearms in magazines currently banned, and the Second Amendment would finally achieve equal status with other constitutional rights. We have to be realistic. There is always the alternative scenario. If the court denies review on February 20th, it sends a chilling signal. It would suggest that despite the Bruen standard, despite clear circuit splits, and despite lower courts openly defying Supreme Court precedent, the court is still unwilling to step into the political thicket of semi-automatic rifle bans. A denial doesn't mean the bans are constitutional. It just means the Supreme Court isn't ready to strike them down yet. The practical effect would be devastating. This would leave millions of Americans in constitution-free zones where their rights are determined by their zip code. Lower courts would interpret the denial as permission to continue upholding these bans using whatever reasoning they can construct. It would embolden anti-gun legislatures to push even further, potentially moving toward the confiscation models we are already seeing proposed in states like Virginia. States would be emboldened to pass new restrictions, knowing the Supreme Court won't intervene. But given the number of relists we've seen for these cases, a flat denial is becoming increasingly unlikely. The justices are clearly up to something. The significance of this moment cannot be overstated. We are currently living through a constitutional crisis in the judicial system where different constitutional rules apply depending on where you live. The question isn't whether these items are common. The data proves they are. 24.4 million AR-15 owners are watching. 115 million standard capacity magazines are in civilian hands. The question is whether common use matters, whether the Second Amendment means anything, and whether the Supreme Court will do its job. Justice Clarence Thomas has been waiting for this moment since his dissent in Freedman v. Highland Park in 2015. He wrote then that the court's refusal to protect the Second Amendment was inexplicable and inexcusable. He's been proven right. Lower courts have spent a decade ignoring Heller and Bruen, creating a situation where the Second Amendment exists in two different Americas. A ruling in Veramontes or Duncan settles the legality of these bans once and for all. It would force lower courts to finally respect the Heller and Bruen precedents. It would be a return to the original intent of the founders, a nation where the citizenry is armed with the standard tools of the era. The AR-15 and the standard capacity magazine are the modern iterations of the flintlock and the powder horn. They are the standard equipment of the modern American citizen. The United States was built by citizens who understood that the right to keep and bear arms isn't about hunting or sport shooting. It's about ensuring that political power ultimately resides with the people, not the government. The Second Amendment exists because the founders knew that an armed citizenry is the final check on tyranny. AR-15 rifles are the modern embodiment of that principle. They're in common use precisely because Americans recognize that self-defense and defense of constitutional order require effective arms. February 20th represents a decision point. The Supreme Court will either step up and enforce the Second Amendment as written, or it will continue the pattern of avoidance that has defined its approach to gun rights for over a decade. The court's decision will reveal whether our constitutional system still protects the foundational principles of our republic, or whether the Second Amendment has been reduced to a relic that courts refuse to enforce when politically inconvenient. On February 20th, we find out if the Supreme Court still believes in that America. The stakes couldn't be higher, the moment couldn't be more critical, and the clock is ticking down.